Hello, this is English Shorthand channel and the shorthand dictation speed is 100 words per minute, which is very helpful for all types of governmental competitive exam. 5 seconds. Ready? Start. Sir, it had been further argued on behalf of the defendants that under section 34 of the Specific Relief Act, the plaintiffs must have a direct interest and entitlement over the property for which the declaration is sought. Section 34 of the Specific Relief Act states discretion of court as to declaration of status or right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so. In the present case, the plaintiffs are not seeking a declaration that they have a beneficial interest. A derivative action is sought only for the beneficial interest of the second defendant. The second defendant has, however, abjured such interest. Whether such disclaimer or abjuration is the result or effect of coalition or fraud are further aspects to be examined. Such abjuration has to be weighed with the flow of funds through the second defendant to the first defendant, leading to the allotment of shares to the third to the seventh defendant. Examining all these aspects can only be through advancing oral on and documentary evidence. This would further imply that the suit has to be retained on file. It had been further contended that the suit relief is barred under section 187C of the Companies Act 1956. It had been contended that preliminarily the third, fourth, and seventh defendant should make first a declaration that though the shares are in their names, a beneficial interest had accrued to the second defendant. Similarly, the second defendant has to make a declaration that they are the beneficial interest holders of the said shares. It has been contended that in the absence of the above declarations, seeking a declaration against the first defendant would be akin to putting the cart before the house. I hold that the declaration made or not made in the books of the first defendant would be to the exclusive knowledge of others. In this context, the 8th to 10th defendants have a vital role to play. Evidence is necessary from their end to disclose facts and to subject themselves to cross-examining on all these aspects. The plaintiffs have pleaded the facts to their knowledge. It must also be kept in mind that except the third defendant, no other defendant had shown to an affidavit. Questions raised by the plaintiffs remained unanswered, and trial is the answer to determine the actual facts. I hold the plaintiffs cannot be non-suited at the threshold. The suit is only at its early stage. It has a rough course to clear. Their reliefs sought may be superfluous, but if the plaintiff discloses a cause of action and if the plaintiffs are prepared to battle out the issues at the time of recording the evidence, then again they must be afforded such opportunity. At this stage, the plaintiffs have come to court preliminarily claiming a declaration as against the first defendant. Whether the third, fourth, and seventh defendants on the one hand and the second defendant on the other hand have made declaration in accordance with the provisions of either section 187C of section 89 of the Companies Act 1956 or 2013 are facts to the exclusive knowledge of the first, second, third, fourth, and seventh defendants are also the eighth defendant. The plaintiffs could never have had access to the records of the first defendant. The queries raised in the pre-suit notices have not been answered. Consequently, they have sought a declaration only against the first defendant. This declaration is sought because in Dubai the third, fourth, and seventh defendants had made similar declaration, and in the plaintiffs have stated that they believed that similar declaration had been made in the books of the first defendant. This statement of the plaintiffs has to be tested further through oral and documentary evidence. Consequently, I am not in agreement with this contention raised by the defendants. Trial is the answer to settled facts. At this state, the plaintiff averments hold the sway, and a reading makes it obvious that the first defendant has to open up its records for scrutiny, and that can be done only during trial. To sum up, the allegation raised in the plaint have to be examined and Chennai, since the first defendant is registered in Chennai during its pre-incorporation, incorporation, and post-corporation stages. Substantial amounts of money had flowed to it. It is only with examination of the books of the first defendant that the source of the fund can be determined.